the parties are dealing with a right which under the contract cannot be assigned. And the court has said it's okay for you to declare a trust of that right. Now, if, like Adelman and Elliott say, an equitable assignment and a trust were exactly the same, that wouldn't make sense. If the contract says the right can't be assigned, which must refer to equitable assignment, if the contract says the right can't be assigned, but you allow the parties to declare a trust, if assignment and declaration of trust were identical, that would make no sense. But the courts do allow a declaration of trust over a right which the contract says can't be assigned. Therefore, the courts must think there's a difference between a declaration of trust and an equitable assignment. So I think an equitable assignment is basically a declaration of trust, but it's just different enough for it to be a separate thing. But I do agree that I don't think it's a transfer. I don't think an equitable assignment is a transfer. And then that makes more sense of the relationship between common law and equity, because common law is saying you can't transfer contractual rights, and equity is agreeing. Equity is saying, yes, that's right, you can't transfer contractual rights. But what you can do is give B valuable rights in relation to the right that A has against X. So the way that equitable assignment is similar to a declaration of trust is because it's giving B a special type of equitable right that's more than just a personal right against A. It's a right that is protected in insolvency. And these special type of equitable rights that you can get, are what I like to call, again, nobody else likes to call, but I like to call rights against rights. What you get if you're B is not just a right against A, you get a right in relation to a right that A has. And that's more than just a personal right. So B's not getting A's right against X, B doesn't get A's right against X, but B gets a right that relates to A's right against X. And that's the beauty of equity, you see. The beauty of equity is it's a secondary system. So common law is here. Common law is the floor that covers everything. Okay? But equity is a secondary system that can float above. It doesn't cover everything. Not everything is covered by equity. But when equity comes in, it can modify the rules that common law has, and it can give people rights that relate to the rights they have at common law. See, common law can't really do that because it's a sort of flat system. It's about what rights you have against people, what rights you have in relation to things. But equity, because it's a secondary system, can come on top and say, okay, those are all the rights you have at common law, but now let's modify what you have to do with those rights. And that's one of the clever things that equity does. It can give you rights, not in relation to people, not in relation to things, but rights in relation to other rights. And I think that's what's going on with equitable assignment. And that's what it shares with the trust. Now, the type 2 equitable assignment is something you've looked at already when you're doing security rights. Now, these are the cases where A is dealing with rights they don't have at the moment, but rights they're going to have in the future. And again, you can do this in equity. That's what you do with floating charges, for example. The only difference really is you have to have consideration. You've got to have consideration here. Okay? And this is just the same as when you did trusts and whether you can have trusts over future property. Obviously, you can't declare a trust over property you don't yet own. But if you have a contract with someone that you'll hold that property on trust, then the contract will take effect and give rise to a trust as soon as you receive the property in the future. Okay? But, that's more to do with, Holroyd and Marshall, Tailby and official receiver cases that you looked at. So that's more important in the context of security rights. For our purposes, when we're looking at equitable assignment, we're focusing on the cases where
A has that right. At the moment, A has the immediate right against the customers and they want to do something with it. Okay? But again, the way equitable assignments work with future rights, is very similar to the way it works for trusts of future rights. And yeah, that's on the handout there. Okay? So, equitable assignments, what you need to understand is the debate is between a sort of transfer view and a trust view. So there are some legal rules you need to look at to see which view fits better. The things to look at are Brandt's case, what they say about it in Roberts, what they say about assignment in Smith and Mannering, and the fact that X is allowed to pay A, at least until they have notice that the equitable assignment occurred. Okay? And nothing's really completely conclusive on it. That's why there's a debate on it. But I sort of tend to the more to the Declaration of Trust camp, just because I think it explains the relationship between common law and equity in a more satisfying way. And it fits in, I think, with the way that equitable rights work generally. But I think it would be a mistake to say an equitable assignment is exactly the same as a trust. I think there are differences, and that will be really important when we look at non-assignment clauses next time. Okay? Any more? Do you want any more on equitable assignment? I think I might just say happy now, question mark. That might be. That's the best way to discourage people from asking anything. Anything else on equitable assignments? Okay, let's have a quick... obviously, if you have a think about it, you might have questions for next time. That's fine. We'll start off on statutory assignment. So statutory assignment, there's a statute. It was originally in the Judicature Act, when they were reforming the court system and thinking about the relationship between common law and equity. And, the statute's there. Now, the important thing about statutory assignments is that it does give B some direct rights against X. Okay. So, in fact, it uses the word transfer. The statutory assignment can transfer from A to B the legal right to the debt, the legal right and remedies, and the power to give good discharge. Okay. So, therefore, when you look at statutory assignment, the overwhelmingly popular view is to say, well, a statutory assignment is a transfer because that's what the statute says. Okay? And also, if you look at the statute, if you look at the requirements for a statutory assignment, they do seem to be there to protect X. The reason we don't like transfers is because we're worried about X's position. So what the statute does is it takes measures to protect X. So you can only do this by giving notice to X, and the notice has to be in writing. And you have to use writing to make the statutory assignment. And it only works for an absolute assignment. Now that's quite important, and they explain this in the Durham Brothers and Robertson case. What it rules out is a conditional assignment. Now, a conditional assignment is you say something like, I will assign this right to you until something happens. I will assign this right to you until somebody gets back from Rome. Okay? Now, the problem with a conditional assignment is there's a problem for X, because if X doesn't know whether JS has got back from Rome, X doesn't know who they should pay. Okay? If you can make a conditional assignment, then X would know, because of the notice, that the assignment had been made to B,
but they wouldn't know whether the condition had been satisfied. So then X is in a dilemma. Do they pay A or do they pay B? So you don't allow that to happen. The assignment has to be absolute. It just has to be right. Now it's B's right. Okay? A mortgage is okay, you know, where you transfer a right by way of security. That's okay. Because it's not the same as a conditional transfer. It's not... When the condition is fulfilled, it doesn't mean that the right automatically goes back to A. In a mortgage, when you pay off the mortgage, you don't get the property back automatically. It has to be transferred back to you. Okay, so you can do... A mortgage is fine, but it can't be conditional. So that's why if you purport to do it by way of charge, that won't work. Because the point about a charge is the charge disappears automatically as soon as the debt is repaid. So you can't have an assignment by way of charge. The other protection, this is sort of skipping ahead a bit, the other protection is that assignment of part of a debt doesn't work in section 136. So if X owes £100 to A, if they like, can make an equal assignment to B of £50 and an equal assignment to B2 of the other £50. But you can't do that with statutory assignments. Because if you could do that with statutory assignments, then you'd get B, B2, B3, B4, all having direct rights against X. Now all of a sudden, rather than being sued by A, as is the case in equal assignment, now X is being sued by 4 different people, which is a pain. Doesn't protect them. So these requirements that it's for the whole of the debt, that it has to be absolute, that it has to be in writing, that you have to give notice in writing to X, these are all there to protect X. Okay? So there's 2 views you can take on statutory assignment. Okay? One view, which is the overwhelmingly most popular view, is to say, look, it's just a transfer. The Act uses the word transfer. B can sue X directly. It's just a transfer. But that's okay because X gets all this additional protection. Okay. But the other view, which is less popular, but it's quite cunning, but it's a harder one to convince people of, is to say, well, look, what is the section actually doing? If you look at what the judge says in Talkington and McGee, what the judge says in Talkington and McGee is the subsection is merely machinery. It says the subsection is merely machinery. What it does is it allows B to sue in B's own name, but really all it is an extra assignment where you do some further things like writing and notice, then you get the procedural advantage of being able to sue X directly. So on this view, the section 136 statutory assignment does work, again, a bit like a declaration of trust. The only difference is B gets this procedural advantage, this machinery, of being able to sue X. Okay? So if you're trying to be really cunning about it, you could say that even a statutory assignment isn't a transfer. Even a statutory assignment is really A holding a right for B, but B getting to sue directly. Okay? And Tam makes that argument as well. Shiho Tam makes that argument. Now that would be sort of, if that were true, if it were true that a statutory assignment is really just an extra assignment plus a few extra bits, that would be quite cool, because then you'd be able to say to people, not only are you wrong to think an extra assignment is a transfer, you're also wrong to think a statutory assignment is a transfer. And that'd be quite good, because you get to tell people they're wrong about stuff. But it might be pushing it a bit. It might be a bit ambitious to make that argument. But we'll have a look at a bit more on that next time, and then we'll look at this big question of what you do about non-assignment clauses, what you do about contractual rights where the contract says you're not allowed to assign them. Right, now the plan, so I'm doing the next 3 lectures, and the plan for the next 3 lectures is that before the lecture, I want you to watch the lecture cast from the previous year's equivalent lecture, okay? So you watch that and think about it, and then when you come along to the lecture, I'm not going to have to repeat it all, but we can talk about the stuff that's interesting, we can look at some exam questions, you know, we can discuss it a bit. That's the plan. So I did that last year for some lectures, and it worked quite well, so that's why we're doing it again this year. And, you know, it might work quite well, it might not, we'll see. But we'll give it a go. The point of it, as I hope you'd realise, is to try and get the most out of the 2 hours here. Because it sort of seems to me that, given we record all these lectures anyway, there's not a great deal of point of me just standing up and giving you a lecture again, when you could just watch it before, and then we could spend the time here like talking about stuff that might help you in the exam. That's the thinking. Okay? The only downside of it for you is it means you've got to find the time to watch the equivalent lecture before we meet next week. That's why I didn't do it for this lecture, because, you know, it was Christmas and what have you. But that's the plan for next week and the next couple of lectures. And like I say, people liked it last year, so we'll try it. You know, if it doesn't work, then just let me know and we'll rethink it. But that's the plan. Does that sound okay? And the good thing about that, apparently, that's called lecture flipping. So you have to say things like, "Oh, I've got to listen to this flipping lecture," and you know, and so on. So that's good. Okay. So yeah, I'll see you next week for that. So please do have a look at that. So what I mean is, obviously, do have a look at the equivalent of next week's lecture, which is this second assignment lecture. Have a look at that before next week, and then we'll talk about it when we meet.